All right, class, settle in. Today, we're doing a high-yield review of one of the most crucial articles in the Indian Constitution, Article 15. This is the absolute bedrock of India's promise of equality. But as you're about to see, that promise has been a real battleground of ideas for over 70 years. So let's start with a central question that has shaped decades of law and society. What did the framers of the Constitution truly promise about equality? And maybe more importantly, how has that promise been bent, stretched, and changed over time? If you can grasp this evolution, you've grasped the very soul of Article 15. Here's our roadmap for today. We'll start with the original rule, the basics. Then we'll look at the first major legal challenge it faced. We'll see how the Constitution itself had to adapt through amendments. Then we'll explore how the courts tried to set some limits. And finally, we'll talk about what it all means today. Okay, let's dive right in. We have to begin with the foundational text. This is the bedrock, the original promise of 1950, and everything else we discuss today is built right on top of this. First thing you absolutely must remember is who Article 15 protects. Now, unlike the broader promise in Article 14, which applies to all persons, Article 15 is a right specifically for the citizens of India. This is a crucial distinction, a classic exam question, so make a note of it. Now for an exam tip. To remember the core of Article 15, there's a simple little acronym, RRC+SP. If you remember nothing else from this section, remember this. It covers the 5 prohibited grounds for discrimination. And that stands for religion, race, caste, sex, and place of birth. Simple enough, right? The state is explicitly forbidden from discriminating against any citizen on these 5 grounds. But, like with so many things in law, there's a huge catch. And that catch comes down to one single 4-letter word in the text of Article 15, Clause 1. That word is only. Its interpretation has been a massive legal battleground. The legal significance of this word is just massive. It means the prohibition isn't absolute. If the state discriminates based on, let's say, caste and some other valid reason, well, that action might actually be upheld by a court. This little word creates a huge loophole, and understanding it is key to understanding the limits of Article 15. So, you have this brand new rule on the books. How did it actually get tested in the real world? Well, it happened almost immediately. The ink on the Constitution was barely dry when its principles faced a huge legal challenge that would change everything. And this is the case. State of Madras versus Champakam, Dore Rajan. You could call this the inciting incident in the story of Article 15. It is absolutely impossible to understand the first constitutional amendment without first understanding this case. The facts here were pretty straightforward. The state of Madras had a policy that reserved seats in medical colleges based on community, basically a form of affirmative action. Champakam Rajan, a student, was denied a spot even though she had higher marks than others who were admitted under that policy. The Supreme Court's ruling was completely unequivocal. They said this was blatant discrimination based on caste and religion, and therefore unconstitutional, period. Now this was a pivotal moment. The court's decision, while, technically correct based on the text, created a huge political and social crisis. It essentially wiped out affirmative action policies designed to help disadvantaged communities. So Parliament's response had to be swift, and it had to be decisive. And that leads us perfectly into the next phase, the evolution of the article itself through amendments. You absolutely have to know the sequence and purpose of these changes to get the full picture of equality in India. This timeline really tells the whole story, doesn't it? Each amendment is a direct response to a court ruling or a societal demand. First, in 51, right after Dore Rajan, they add Clause 4 to allow for reservations. Then, in 2005, they extend that power to private institutions. And then most recently, in 2019, they added an economic criterion to the mix. It's a constant back and forth. But as the scope of these special provisions got bigger and bigger, the next logical question for the Supreme Court was, are there any limits? Or can the state just create reservations without any checks and balances? And that brings us to the big one. This case is often called the Mundal Commission case. And if Dore Rajan was the start of the story, Indrasani is the climax. It is, without a doubt, the most comprehensive and authoritative judgment on reservations in our constitutional history. So this massive 9-judge bench laid down 4 critical principles that still govern reservation policy today. They balanced the need for affirmative action with the need for general equality. They did this by introducing the creamy layer concept, basically kicking out the well-off members from getting benefits. And most famously, they established the 50% ceiling on total reservations. Okay, let's bring it home. We'll fast forward to the present day to see how the judiciary keeps expanding the meaning of that original text. This is what we mean when we say the Constitution is a living document. This landwork case asked a really profound question, and it was about the meaning of just one four-letter word in Article 15, sex. The question was, does it mean what the framers thought it meant back in 1950, or does it mean something more today? And the court's answer was a resounding yes. By striking down Section 377 of the Penal Code, the court affirmed that sex under Article 15 is not just about biological markers. It also includes sexual orientation and gender identity. This is a perfect example of progressive constitutional interpretation in action. So what's the key takeaway here? The main thing to remember is that Article 15 is not some static rule that's frozen in 1950. It's a dynamic, breathing principle that our country, through its courts and its parliament, continues to debate, define, and expand. And that's the final thought I want to leave you with. As our society changes, our understanding of this fundamental promise of non-discrimination is going to change with it. The story of Article 15 is far from over. Good luck with your preparation.